Good afternoon, ladies and gentlemen. I would like to welcome you to our session today on the 13th day of August 2020. We are hosting this session and it is being broadcast from Nairobi with the American Corner Moi on their Facebook page. And this is in partnership with the Wasilianahub Mediators Africa. This is part of a series on mediation and dispute resolution, whereby American Corner Moi and the Wasilianahub Mediators Africa community will be engaging with the public through various channels so as to enable more people within Kenya and also out of Kenya to have a greater and better understanding of mediation as a practice and also other families, nations, and their disputes amicably. At the center, allow me to invite Madam Emily Okeyo, who is the convener at the American Corner Moi. Emily, good afternoon to you.
Good afternoon. Thank you. Good afternoon,
Yes.
Wangari.
Good afternoon to you.
And our viewers on Zoom and those tuning in from Facebook, American Corner Facebook page. So as Wangari has said, today we're going to listen to a talk from her on the issue of mediation and dispute resolution as an introduction. And we will be hosting a number of series of sessions such as this on the Zoom call and on our Facebook page. So you are most welcome and to keep on tuning into these sessions. Wangari is from Wasilianahub, and she is a professional mediator, and we will be getting more insights in this topic from her. So as she's going to take us through the topic in an introduction to mediation, please hold on to your questions and comments towards the end of the presentation. So we will be able to interact with her at that time. So thank you so much for viewers for tuning in from wherever you are. And Wangari, you can take it away now.
Okay. Yes, thank you very much, Emily. And mediation is quite an interesting topic because it is something we actually even do in our day-to-day. Just probably we do not call it mediation, or it comes in many terms and languages. So I'm delighted to be with you, and also thank you to the colleagues who tuned in and also those who are listening. And we hope that this session will enable persons who are listening in to be able to get a very basic introduction to what mediation is. At Wasilianahub, our mission is that persons who are in disputes will actually choose mediation first. And our mission is that it's actually at the individual level for families, for businesses, and also generally for our communities. So, Emily, our session today is for the next 30 minutes as an introduction. As Emily has introduced me, so my name is Wangari Kabiru, and I am a chartered mediator. And in the tied to that also, I am a certified professional mediator. So that means that I have taken training to be able to understand mediation and to be able to journey with persons who are in dispute and support them through a tool. Let's consider it as a tool known as mediation. I convened Wasilianahub, and I will give a brief about Wasilianahub in a short while. I convened the community that is known as the Wasilianahub Mediators Africa, which is a community that kicked off from Kenya and is growing a community across East Africa and moving on to Africa to grow a community of professional mediators. So I enjoy a couple of things. I enjoy technology, I enjoy matters to do with enterprise, travel, and in my journey in life, I make small things big and transform them to be huge. And that's really the journey we are on as Wasilianahub. So to move us on into the area of the topic today, mediation and dispute resolution, I would first look at what we can call various forms of dispute resolution. Various forms of dispute resolution, and we have a number of them, which include one, mediation, negotiation, arbitration, and litigation. I will highlight on what each of these forms of dispute resolution, which are the main ones, because we also have conciliation, we have other forms known as such as expert evaluation, but we will focus on just an introduction on negotiation, mediation, arbitration, litigation, and then now move into now being able to have a better appreciation of mediation using what we call at Wasilianahub STARS mediation. STARS mediation is a model that is actually referred to as the Peppermint STAR model of mediation, which actually takes you through in terms of how to be able to carry out a mediation. So we will start off with negotiation. Negotiation is a form of dispute resolution, and I actually prefer to consider them as tools. I call them tools that you can be able to use. So negotiation as a tool when you have a dispute is when the parties themselves, it means the persons who have the dispute, talk to each other about the problem they have, and they try to reach a solution that is acceptable to them. So in this instance, then it would mean if Emily and I have a dispute, then Emily and I would say, let us meet for coffee, or Emily, let us meet at your office, let us meet at my office, and let us talk about this problem, and we try to reach a solution that is acceptable to both of us. Here, key is that it is the parties themselves who have the dispute, who are talking to each other about their problem, and they try to get to the solution themselves, and here it is a solution that is acceptable to them. So that is negotiation. If we take a reflection, this is a very common form of our mechanism that we use in our homes, even in our businesses. If you consider, for instance, a supplier of services to your organization, whereby there has been, let's say, they supplied goods, and when you counted, maybe they were pens. When you counted, on your side, you say no, the pens were 15 packs. They say no, we sent the 20 packets that you asked for. This, in many of these instances, you will find that your organization and the supplying organization, you will sit and agree in terms of how to handle it. Or for instance, there was a damage to the pens, or maybe it was milk being delivered at your offices, and some of the milk packets, by the time you are receiving them, they were open. So you will have a discussion with the supplier of the milk and agree in build. You will have a discussion with the supplier of the milk and agree, will you, for example, pay for the full consignment, or will they actually add some additional packets to compensate, or will they knock off from your invoice the quantity of the packets which seem to have been destroyed? So key things here, the parties who are talking to each other is you who is in dispute together with the other person about the problem, and then you agree on the way forward. The next form of dispute resolution that I will highlight on, and just briefly, and then we will come back to it, is mediation. So mediation is whereby someone who is not involved in that dispute helps the parties who are in dispute to talk about the problem and also to settle whatever is their differences. We will come back to mediation, but key here is that there is another person who is coming to help them to be able to talk about the problem that they have, and also to help them to settle their differences. So we will talk about mediation more and get to explore what we mean by that. The other form of dispute resolution is arbitration, and here when I talk about arbitration, so arbitration is whereby, again, the parties who are in dispute, the two organizations, the one that supplied the pens and the one that was receiving the pens and said the pens were not the type they were looking for, or some came as broken, they agree to have another person. They agree to have another person to come in and listen to what the arguments they have. and then that other person will make a decision for them. Now, let us pick the key points. Now, let us get the key points. The key points are, we have the parties who are in dispute, and they themselves, they agree to have another person to listen to their arguments, and that other person who listens to their arguments then makes a decision as to what will be the way forward. I hope we are able to see the distinctions here, with especially when we talked about negotiation. Negotiation, we said the parties themselves, they talk to each other and they agree on a way forward themselves. Now, we have litigation. Litigation is what many people would be familiar with. Litigation is when we say tukutane kotini. That is a phrase not maybe too common to many people, but we are familiar with it. Tukutane kotini. Tukutane kotini simply means let us meet in court. And that is now when we talk about litigation. So litigation, we have the parties. In litigation, we have the parties presenting themselves to a third party hearing. That is when now we have a judge, we have a magistrate, and it is in a court situation. Now, the methods that I have talked about are 4 of them, and the 4 mechanisms that I have talked about for resolving a dispute, I've talked about negotiation, mediation, arbitration, and litigation. Each of these forms have their weights, and each of them have their purposes, their usefulness, and when they are most effective. So in today's session, where we have an introduction to mediation, together with the American Corner as part of the leadership and governance theme, we will focus on mediation. And as I mentioned earlier, we will focus on mediation based on what is known as the STARS model of mediation. The STARS model, at Wasilianahub, we add an S. The model is actually referred to as the Pepperdine STAR model of mediation. And I will explain to you why, as we have developed the use of the model at Wasilianahub, we have added the S, which for us is sustainability. So the STARS model stands for stage, what is the task, what is the action, and what is the result that you're looking for. So the STARS model in itself is not what you will use in mediation, but it is a methodology that you use as a practitioner, or even you who is having a dispute, so that you can be able to move step by step. And as you move step by step, then it enhances the effectiveness of your mediation. As we're finishing the next, which is in the next stage, we will look at what are some of the benefits of mediation and what makes it sometimes more favored versus some of the other mechanisms. So I have mentioned that today we will look at the STARS model, STAR, with an additional S, and this model is known as the Pepperdine STAR model of mediation. In this model, you go through what is the stage you're in, what tasks need to happen, the actions, that is the how, and what are the results. And as I've said, for us, we also add an additional S so that we look at how to make it sustainable. Now, the Pepperdine STAR model of mediation looks at 5 steps that are in the stages of mediation. So it breaks down the stages of mediation as number 1, the convening, number 2, the opening, number 3, communication, number 4, negotiating, number 5 is the closing. So we have said that in the STAR model of mediation, when you are conducting mediation, these are the steps that you will take. The steps that you will have is, the first step is a convening, and in convening the mediation, then this is when now you bring the parties together. So bringing the parties together could be in various forms. Emily and I, in our dispute, then Emily could actually now contact a mediator who is not involved in this dispute, and then invite that person to engage us. So that person who is acting as the mediator then will contact me and inform me, Wangari, Emily has requested that I invite you for a mediation to resolve on the matter of the pens that were supplied to their organization. So at that stage, the mediator is convening the mediation. Now, what are the tasks? We have said that the STAR model has four activities, which is what is the stage? You look at the stage. What is the task? What is the action? What is the result? And in addition, I have said that for us, we have added an S on sustainability. So when it comes to that stage of convening, what are the tasks, or what is the task? The person who is now to mediate the matter will engage me. So the task is for them to reach out to me because Emily has contacted them. Then the person will now reach out to me. They could either send me an email, or they will call me, or other ways, probably a physical meeting. If it's a mediator, who could invite me either to the office or request to come to my offices. Then the first task is that the party who has requested for the mediation and the other party actually get to know that there is a mediation being called for. Now, so the actions then that follow at that particular point is then you as the mediator then will now have a discussion with both sides and get to understand what to them is the issues, or what is the issue with regard to this particular situation, and based on what the issues are, what is each person's interest, and how would they best like it to be resolved. The next stage that now you move into, so the first stage is convening. The second stage in a mediation is now when we get into the mediation, and we can call it the opening session. So the second stage is the opening session. This means that now we have the two parties who are in dispute. As the mediator, I have now brought them together. And in the opening section, I will now invite the parties to give a highlight when now we are together. Mediation happens, and that is one of the unique things about the mediation, that the parties are brought together, and then the mediator is also with them. Remember, we said that the parties in dispute, and they invite a third party, and this third party is a neutral, meaning they do not have an interest in the matter, and the third party helps them to be able to work around what is their disagreement, and they come up with a way forward, which is what we call the agreement. So in the opening session that I as a mediator will have with the parties, then I will explain to them the mediation process. Remember, I have highlighted that we now have the parties together with the mediator. This could be remotely, considering even today we now have online dispute resolution that is now virtually, or it could actually be in the physical sense. So in explaining to them that how the mediation will run, a very important thing, and this is a very important stage for any mediation, because mediation, one of the distinctions with the other models, and especially on litigation, is that mediation is voluntary. The parties choose to engage in the mediation. So after during this stage as a mediator, I will take them through the stages of how the process will go, and I will also give them some of the ground rules. Some of the ground rules in a mediation are, for instance, some seem very basic and obvious. If one party is speaking, allow them to speak to finish. Do not jump in and cut out the other person when they are speaking. Give them their airtime. Secondly, we always make sure in a mediation that parties are using language that is acceptable. And then also, thirdly, that everyone is committed that the matter can be resolved. So in this stage, you as a mediator, what results are you aiming for? Or in when that stage, a mediator is taking you through that stage? The mediator is trying to give safety and also to give the parties hope. The mediator is trying to project safety and also to give the parties hope that yes, it is possible. It is possible that we can be able to resolve this matter. And it is possible that, yes, I know that you have been handling this matter for the last 5 years. Yes, Madam Emily, I know that the supplier of pens, this is the 5th time they have supplied to you the broken pens. But in this mediation today, it is possible that we come up with a way that is sustainable. So in the STAR model, I say again, is what you look at the stage you're in, the task, which is what you need to do in that stage, the actions, and the results that you're looking for. So right now we are in stage number 2. The first stage was the convening, where as the mediator, I communicated to the parties so that we can bring them to the table. The opening, now I have brought them now. We are in conversation, and in conversation either physically together or we are virtually, and the disputants. And so in the first stage of the convening, I was trying to get them to be willing to participate in the mediation. In this second stage, which is the opening, I am trying to get them to feel safe, that yes, it is safe for them to be in participate, and also to give hope. In the third stage of our STARS model, in the third stage, it is the stage that involves communication. So in this stage, the task for me as the mediator, so in other words, at that particular point, what am I doing, or what am I trying to accomplish? In the third stage, I am trying now to get the parties to communicate. So I allow the parties to explain their positions. When we would use the word positions, when you have a disagreement, you have your stand. That other person is wrong because of this and that. So that is the position, that is your position that we are now talking about. And when you have that position, then it is part of what may not be clear to the other party, and that could also be part of the problem why you have the dispute. So at this stage, you will find in a mediation that as a mediator, I will ask open-ended questions. And when I ask the open-ended questions, then those open-ended questions, there is active feedback from the disputants. When I say active feedback, I am encouraging each of the disputants, the two sides that have the dispute, to talk as much as possible, because it helps me to be able to understand what is their perception of the dispute, how exactly are they feeling about it, what exactly has been affected or impacted as a result of dispute. And that for me, this stage for me as a mediator, is critical, because the more attentive I am and the more I am able to ask active and open-ended questions, the better I will be able to support the parties. Now, sometimes we can ask ourselves, oh, this looks like when you're cross-examining, the parties when they are in court. Actually, in a mediation, this stage of communication is actually much more difficult, because you ask very delicate questions, and as a mediator, you have to be very skillful, and at the same time, you are trying to cause a conversation to move forward. You're not just asking questions for yes and no. You're looking for the parties to open up and explain themselves very willingly, so that you can be able to help them. Now, so the result at this stage is that the parties get a chance to air their perspectives, and they get to feel confident. Okay, so remember, in the earlier sections, in the convening, we said that the result is I was looking as a mediator for the parties to be willing to participate in the mediation. In the second stage, which is the opening, I was giving them safety and hope, as I was explaining to them how the mediation process will work, and really just giving them assurance that it will work for them. In this third stage, which is in communication, I am giving them a chance to express themselves. We now move to the next stage, which is of the STAR model, which is the negotiation. The first stage is convening. The second stage is the opening. The next stage is communicating. The third is the fourth stage now is the negotiation. Negotiation, just as we said earlier, is going back and forth. And at this particular point in time, because I will get into a negotiation stage as the mediator when I feel that the parties have communicated as much as possible, so that they feel understood, and also I have been able to understand actually what is the dispute and what is affecting each party. So at this stage, which is the negotiation stage, I have to be very timely on when I move the discussion to the negotiation stage. Why am I saying I have to be very timely? It is in the stages that we have been journeying through, when convening, the opening, communicating, I have been preparing them. And if I jump into negotiation before they are into the negotiation stage before they are ready, then I could easily jeopardize the parties being able to get to an agreement or being able to have a way forward that is understood and agreeable now to themselves. So at this stage, I want us now to take us back to dance moves. This is a stage of dancing between the parties. So now Emily will say what she's saying and how she wants this to be concluded. The pen supplier will say how they would want it to be concluded, and I will keep bringing them back to Emily and your pen and the pen supplier. Remember, you have a long-term relationship. You have had a relationship for the last 15 years. So these are cues that I have been able to pick, and also from their discussions. For example, Emily might have said that for us to get another pencil supply, it takes another, 15 months or 15 years, and it's a very difficult thing because of the types of pens we need. The supplier may have said, the ink we use is only especially for the two of you. So in the negotiation stage, I get them into a dance mode. And in that dance mode, then it is possible now for us to be able to pick what is the best way forward, so that each of the parties actually feels and experiences that at this stage that they have been honored in what this next stage that we're moving into, which is the closure. Now, in this negotiation stage, the result here is very, very key. The result is on flexibility and innovation. This is what makes mediation one of the most wonderful tools that you can actually be able to use, or you can be able to offer. If you are a mediator, this is actually the magic that you bring into the dispute resolution mechanisms that are available. You bring in flexibility and innovation, because when you are in the various stages of convening, opening, communication, and negotiation, even the parties themselves are able to explore into what are new ways that they could be able to resolve their dispute, and at the same time also be able to avoid the dispute happening, or even in future be able to prepare in case such the dispute or a collision situation will come again. So we have talked about the 4 stages so far of mediation: convening, the opening, communicating, negotiating, and now we get to the 5th stage, which is the closing. Now, the closure of the mediation. In mediation, we talk about an agreement, and that actually is the final task for you as a mediator. When the parties agree, then now we have what is called an agreement. In many jurisdictions, in many areas, and in many situations, even if they are not, let me say, what you can call mediations that are for companies, or even if they're for families, normally you will find agreements are written. But it is not a must. An agreement can actually be that it is in words, and that also works. But we commonly are finding that agreements are in writing. Just as same way, for example, you talk about a corporate contract, you'd also find them to be in writing. Now, in a situation whereby the parties may be having their counsel or their lawyers with them, their counsel can be involved even in putting down the agreement, or you as a mediator can actually put down the agreement, and if the parties have counsel with them, then the counsel or the lawyers can actually go through and now be able to confirm that yes, it is what has been discussed, and their parties, that their clients are actually happy with it. But if the parties do not have a mediator, and not a mediator, a lawyer, and it is extremely important to clarify that mediation, parties can actually engage in a mediation without necessarily having a lawyer, because it is actually the parties who communicate what are their interests, what they see as the best way forward. So the closure section, where we have the agreement, is when we say that the parties have had an opportunity to make an informed decision on the settlement, and this comes as a result of the stages of mediation. So in this stage of closing, what we are looking out for is that the parties can actually have an informed decision. informed. In other words, they are aware of it, and it is actually their own decision. So just as I said earlier, in the STAR model, it looks at what is the stage, what is the task, the actions, and the results that you're looking for. The tasks and the actions, those depend on the type of the mediation, but the stages and the results are more or less the same. So I mentioned earlier that in our process of mediation at Wasilianahub, we actually work with the STARS model, meaning it also ends with an S at the end. So we have a stage which we call the sustainability stage. And here what we're looking for is how we can be able to support the parties in compliance with now the agreement, which they have been able to make during this process. For us, the reason why we have the STARS model is because we engage very heavily in community mediation. And in community mediation, so we engage with a lot of grassroots, in other words, with Wanjiko. And Wanjiko has a lot of issues that she's dealing with. The issues to do with disputes seem to be something that Wanjiko considers that someone else should make the choice and decision for them. So as we have been introducing mediation concepts in our villages through the local chiefs or the politicians, then we have noted that it is important that we introduce a mechanism that supports Wanjiko, in other words, we the citizens at the grassroots, on how to be provide mediation as a more sustainable mechanism. So the result in this stage for us is we aim for compliance, and what we do is then we also schedule for follow-up sessions with the parties, and this could be together or individually. So I go back again. So today we have been looking at introduction to mediation, and this has been a joint session with the American Konamoi together with the Wasilianahub Mediators as part of a series where we will be having various discussions on mediation and dispute resolution so as to help the public to be able to understand mediation and various ways that mediation can be applied. So we have looked at different forms of dispute resolution. We have talked about what is negotiation, making a distinction between them. What is negotiation, what is mediation, what is arbitration, and also what is litigation, which is tukutane kotini. And then we have spent our time looking at the Pepperdine STAR model of mediation. In other words, for us, STARS mediation, which has first, you look at what stage are you in. Next, what are the tasks you need to undertake? What are the actions, the results, and also you also look at how to make sure that it is going to be sustainable. So you look at the sustainability mechanisms or what to do so that you can enhance on compliance. So my name is Wangari Kabiru. I'm a chartered mediator and I convene the Wasilianahub community. I'd like to thank you for joining us in this discussion. Over to you back, Emily, kindly. Thank you.
Okay, thank you very much, Wangari, for a very good session and bringing clarity more to what mediation is. And as we know, as human beings in our way of life, we cannot stay away from conflict. So we can see mediation is a good way of resolving our issues instead of the normal thing of saying tukutane kotini. Thank you very much for a very enlightening discussion, Wangari.
Thanks. So, karibu and karibu.
Okay, so if any of our listeners have any questions, they can bring them forth. I have a few questions, by the way, Wangari, from a few of our people from American Corner. And there's the stage of convening, yes, at the stage of convening, where you talk to one party and you reach out to the other party. When reaching out to the other party, don't you get hostility? How are you able to curb that hostility and to make sure the other party gets to participate in the process of mediation?
Yes, Emily, I may respond to that?
Yes, please. Yes, please.
Okay. So yes, your inquiry is with regard to a very critical stage of which is the convening. And if I may just go back, convening is the beginning, and the result you're looking for at that stage is that the parties will be willing. Now, You can imagine where you have a situation. Let us take a situation, for instance, even a family situation. You have a couple and they have not been seeing eye to eye, and it has been for 1 year, and they have not been seeing eye to eye, and then you're contacting now one of the parties to tell them that, oh yeah, Mary would like me to invite you, John, so that we can have a mediation, a family mediation. As you say, it is human that anyone who is being invited to a mediation may firstly sometimes consider it with suspicion. Number two, it is human that a possible first reaction is to resist, and especially where the mediation invitation is coming as a result of an invitation from the other party. And thirdly, it is very human that in the minds we could be thinking about biasness and such. So that question is very relevant, because then it brings in the aspect of the mediator. Remember, the mediator is a third-party neutral, and the reason why we have professional mediation as a growing career and profession in Kenya and also in other countries is because then, as a mediator, you learn you learn techniques which you're able to apply so that you can be able to invite the parties to the mediation, and they can actually consider to come to the mediation. I will say that when handling a mediation, you don't just call the parties. I undertake research on. If Emily is on who has contacted me and told me, yes, our supplier, this has gone wrong. So as a discerning professional mediator, then I will I will take my time to listen to Emily. I will also, as much as possible, research on the other parties if it's possible. For example, if it's a company, sometimes I could find, oh yes, from the news and other views, it's a company that's maybe in distress, or this is the first time even people have been talking and saying about the way their pens have been having issues, just from our illustration earlier. But I will say that the mediator, this stage strongly relies on the mediator. And I'm saying this in as much as we normally say that and have it that mediation is a voluntary process. The parties come on board. But you as a mediator have a lot to do with being able to invite them to come on board. Allow me to also point out that mediation has also been adopted in the courts. We have what is called court annexed mediation. Court annexed mediation or court referred mediation is when our supplier of pens and their clients, their lawyers, go to court, and then when the judge receives the matter, the judge decides that this matter should be sent to a mediator. So now that becomes a court referred mediation. In that instance, you will normally find that people will come to it because nimetumwa na koti. So the court has sent me there. And it is up to you now, the mediator, during the opening session, which was our stage 2, and even during that time when you're convening the mediation, in your conversation with them, to really convince them that, and to really, as you talk to them, that mediation is actually the way for them. So Emily, yes, it is human, and we encounter that, but it is in the training and in the skills and in the experience of the mediator. And most of all, when I'm saying this, is because you as the mediator are able to walk the other party through what is at stake and how mediation can actually help them. So Emily, that is how we normally work around it. Being able to bring out to the parties what is at stake and just how mediation could be the difference for them in as much as the other ways they could have adopted. Emily, thank you.
Okay, thank you very much for bringing that out clearly. There was also another question in regards to the period a matter can be resolved during mediation, because as we know, court cases can take forever and ever. Is mediation, is it similar? The time period, is it similar, or is it shortened? Wangari?
Thank you. Okay, Emily, yes, thank you for that question. And now that question brings us to the area where we now normally talk about what are the benefits of mediation. Allow me to take us back again to when we discussed with regards to the Pepperdine model, and we were looking at what are the results at each of the stages. At the convening stage, the result you're looking for all you get is the parties are willing to engage. In the opening, you create safety and hope. At the stage of communication, then you allow for expression, so you give them a chance for expression. In negotiation, you provide flexibility, or mediation provides flexibility and innovation. And in the closing, then we now have informed choice. The results here is actually what makes mediation a magical mechanism, and why people, once they have experienced it, they will come back, and they do come back again and again. Now, the significant benefits that mediation provides, and this is what I will use when I'm going through the benefits to tie in the inquiry that you've asked with regards to this question. So first, number one is the parties have greater control of the mediation process. Remember when I've talked about mediation, I have highlighted that the parties are the ones who come and the parties talk. And once the parties talk about their differences, the third party, who is a mediator, then as Wangari, I help them to talk about their problem and to settle their differences. So we say mediation, the persons involved in the dispute, so I'm sorry, in mediation, a person who is not involved in the dispute helps the disputants to talk about their differences and settle their differences. Mediation gives the power back to the people. I have highlighted that as Wasilianahub, we do run a community mediation program, and yes, it has taken time, and in quite a number of situations, it is not a very straightforward, when I say straightforward in terms of its acceptance, because people are not used to being the ones in charge of their destiny, whether because of the way we are cultured, or it's whether because of you imagine that yes, your decision is not the right one, or because of power issues. Now, so mediation gives control back to the people. Remember, when you say we are giving control back to you, it means you actually determine, you yourself, you determine then how long this process can take or will take, or you can have control of that. So secondly, the confidentiality of mediation. If you're going to have a matter that is going to be in court, in public court, and in many situations, if you're in one of the courts in Kenya, then in many situations, unless for cases that are, let's say, closed for one reason or the other, then anybody can be involved in your matter. We can come in and sit in, and all of us listen. So mediation makes sure that it is confidential. In other words, only the persons who are involved in the dispute get to sit in that mediation chamber when we are running the mediation. Thirdly, mediation is voluntary. I said earlier that yes, one party will approach you, or if not the party, then their legal counsel will approach you, and now say, okay, Wangari, I have this client, or Wangari, I have this dispute with Emily. So could you please, I've heard you're a mediator. Can you please support us in this mediation? So that voluntariness also is a key factor in terms of that also influences how long this matter will take, because they have brought themselves there and they have the willingness to be able to resolve the matter that is in dispute. And also remember, I said earlier, it is in their control. Fourthly, we could also consider that for mediation can also bring in now a faster outcome. And this faster outcome mainly comes because of the three things that I have highlighted earlier. The parties themselves have control. It is confidential, so we don't have, another whole group of people who are out there who are micro advisors in this process, and that is also part of what delays matters from being resolved. And also, we say that it is voluntary. So these three things of greater control, the opportunity for confidentiality, the voluntariness, is also what helps in the area that relates to faster outcome. So this faster outcome is what, Emily, you have asked about. That faster ability for faster outcome is what now contributes to something that is very significant when it comes to choosing mediation as a dispute mechanism, whether you are an organization or an individual. Costs are greatly reduced. Costs are greatly reduced because you are in control of this matter. It is not because that a mediator is cheap. No. That is a delusion. It is not because that you will not need to put in your time. Very important, because you are the one in the dispute. but the costs are greatly reduced because you take charge of the matter. So you take charge of how much time you want us to be in that mediation. And also remember the experience and the skill of your mediator also in listening and also being able to navigate using the techniques of that we apply as mediators can also help you to manage in terms of time, and also not only in terms of time, which helps your costs, but also at the same time be reduced on the number of people who are involved to the persons who are must be. Convenience is also a key thing. In mediation, you can actually be able to plan that can we have the mediation on Thursday next week? If you're choosing litigation, the court plans for you based on its diary. Now, this now hits the hammer, the nail on the head, Emily, with regard to when the court decides, and today let's take the situation of probably the Kenyan courts in this and COVID at present. Courts were on a slow. They say they have not closed, but they want to slow down as we were getting to understand COVID, and now courts have opened, but they really are dealing with what is very, very urgent. So if you need a matter to be resolved as an organization, you're probably a retail supplier of goods, and the manufacturer has stopped supply to you. If you choose to go to the courts, then unless your matter is put in with very high urgency, you could be on the calendar next year. That means possible loss of business, possible loss of the supply of goods that you are relying on, and at the end of the day, a possible loss of customers because your shelves now do not have the goods that you are dealing with. Finally, in this aspect, I have tied in looking at the aspect that you asked with regard to the duration it takes to also bring out what are the actual benefits of mediation. A very powerful element of mediation is the preservation of relationships. As a mediator, remember in the stages of communication and moving the parties to negotiation, I am cognizant that these parties will need to relate again. Why do we say this? If it's a husband and wife, that is their family, that is their marriage. If it's a corporate client, it is a supplier of goods, and it is a supplier of goods and a retailer. This supplier of goods, this is one of their channels of business. So I am cognizant that that relationship must still go on in as much as this aspect that is in dispute requires to be resolved. So that is one of the strongest benefits for mediation. So Emily, the period of time a mediation takes, today, if you have a mediation that has been referred by the courts, then the courts will give a duration to the mediator in terms of have this matter engage the parties, and if the matter is not resolved, if it's in, let's say, like in 60 days or 90 days, then the matter now will be taken back to the mainstream litigation or any of the other avenues. But when you're conducting a private mediation, matters that I have handled matters which have taken 3 hours, and typically 3 hours is an average time for a mediation chamber sitting. I have handled a matter which took us the whole day. It was a land matter, and it was actually a matter that I was handling, and we were actually doing in Kiswahili. We did the mediation agreement in Kiswahili because that is the language that the parties could be able to understand. I have handled a corporate matter which has taken us having 4 sessions, and these have been 4 sessions back again based on the flexibility, which is a benefit because it is the parties who were able to plan the time now with myself. Then it took 4 sessions, and an average session is 3 hours. So the period is really not one that you will say it is 3 months or 2 months. There are mediations that go on based on the complexity, even for a year. A mediation could be for an hour because it's really dependent on the matter. But the position is that mediation gives control to the parties, and the control of the time it will take is actually one of the great controls that the parties have themselves. Emily, thank you.
Okay, thank you very much, Wangari. That was a very good explanation for the time period spent on mediation. And we can spend a few minutes to open the floor to any of our participants if they would like to ask a question or two. Thank you.
Okay. Okay, ladies and gentlemen, if you would wish to make a comment, I know on this call, we have a number of persons who are also mediators. You may also be able to add in your input. And as I say that, I see an inquiry from Ruth Mwangi. What is your observation about gender preferences during mediation? So in responding to Ruth Mwangi, when it comes to corporate related matters and the ones that I have had the opportunity to handle, I have not necessarily experienced a bias. And when I say I have had the opportunity to handle, is because as Wasilianahub, we have requests that come to us because we host a panel of mediators, and we have had requests that have come to us. And when we have referred 2 or 3 mediators, it has never been in a situation, we have not had a situation whereby there has been expressly, yet please send me, please send me 2 men, or please send me 3 ladies. And when I'm saying we have not had, I will say accept, and I will come to accept accept actually 2 situations where we did have that. And so the issue of gender, well, the area that I've greatly experienced it is in the area of family mediation. And allow me to first clarify on the gender element and on family mediation. We have had requests, and probably quite similar to people when they are doing counseling. And it's to me a mama. I want to me a mama. I would like to have a lady handle this matter. And we have had situations where we were not able to refer a lady either because the time was not working, the timing was not working. And in such situations, even where we have referred gentlemen to be able to support the parties who in family matters had requested for a female, the mediation has still worked, and it has worked very well. So I will say that yes, the public may actually request, or the public may view that there could be a gender, let me say a gender bias. But for practitioners, I have found that in many cases people are gender neutral. The 2 matters that I have highlighted where there was a request, and basically that one was very clear, and it needed to have gentlemen. One of them was needed to have gentlemen referred to them. This was family matter, and the persons who were in the case, it was gentlemen, and the gentlemen were actually having an issues with the ladies married in their family, and they were the ones who are now following up for how can this be resolved, how can the family matters involving land, wealth, and such. So in that particular case, we actually explored with them why was it that they needed, a gentleman, that already comes in, it's like a feeling of a bias, and it highlighted to us now that second level about what the dispute was. So I'll tell you that in that particular case, the matter was actually handled by a female mediator, and it was handled well. Now, you remember when we were talking about the stages of mediation, we talked about the convening, which is the stage of willingness. The willingness stage actually goes both 2 ways. Even the party who's coming to you to say, we would like to have a mediation, it is important you explore to them why do they want to have a mediation, what are the issues on the ground, and at the same time, what is the experience of the other party. So if you recall when I said they came and they said they wanted a gentleman, and if you had just taken it on face value, then probably we would not have been very, very helpful to them, or we were able to be very helpful to them when we now explain to them how mediation works, and it doesn't matter what is the gender. And this convening stage also helped now the mediator who took up the matter to understand some of the differences that were there. So that is what I would say on the gender element. Now, so that was an inquiry from Ruth. We have an inquiry from Joyce Dennis, who's asking how are mediation charges determined and how different are they from lawyer charges. So Joyce Dennis, thank you very much for your question. this is an area that we will be handling in one of the sessions that we will be making a follow-up. This session today, we were looking at an introduction to mediation to help us to be able to understand what mediation is and what are the stages of mediation. But to just give a highlight, so in Kenya and also in quite a number of countries, you will find that mediation works in or is provided in a number of ways. You have private mediators, and you also have mediators who are part of mediation panels. And also you have what we earlier said is called court-mandated mediation. Now, each of these forms then would have different ways or different parameters by which mediation is charged or mediation services are charged. As a private mediator, then a private mediator would have their rates, and it depends on just in general for a private mediator, and also mediators who are part of mediation panels, it is dependent on the amount of time that is spent. I have mentioned that an average mediation is normally allocated 3 hours, so you would find a fee that is for the 3-hour block, and then subsequently every other hour, then a fee for it. Still on the area of fees, then you would find that mediation would be charged based on the experience of the mediator as just one of the elements that could influence what is the experience of the mediator and also the region. That is one of the very flexible elements of mediation. Court-referred mediation, then in a country like Kenya at present, then the court bears the cost of the mediator to provide the service. You will find that there could be other costs, and those other costs then are borne by the parties. Now, if it's a private mediation or a mediation by a panel, you will find that in most instances that the mediator will have the parties sign and make a deposit or make an upfront payment for the standard hours. And this is part of the agreement. At the convening stage, there are various documents that the mediator will send over to the parties, and one of them includes in terms of what is the rate sheet, and at the same time the parties then will agree on who is paying. Will they pay 50-50, or it's one of the parties who's actually going to pay the fee? So Joyce, Dennis, and also for the other colleagues on the call, we will be exploring in terms of the fees that someone would need to prepare for, whether you're a company or a family situation or other types of mediation, as we move on to the subsequent sessions. Thank you for the question. Emily, is there something else you'd like us to respond to?
I think that is all from me, unless there are any other queries from the participants or anyone who would want any clarification. But I would say this was a very informative session. Wangari, thank you so much for highlighting and informing us more on mediation and dispute resolution. We will be having more sessions as a series on mediation in partnership with the American Corner. So more of this will be happening on our Facebook page, American Corner Moi, and we will learn so much more. And I know Wangari has a lot in her plate to do to show us on what mediation is, in order for some of us even to avoid going to the courts for matters which can be resolved very easily and without spending a lot of money. So thank you so much, Wangari. And I want to also thank our participants for viewing and listening in on the Zoom session, and those on the Facebook page. Thank you so much, and tune in for many more of these talks. Thank you, Wangari, and thank you, our participants.
Okay, Emily, I would like to thank the American Corner for this opportunity. We look forward to advancing on in this partnership that we have. It is part of our vision as Wasilianahub to enlighten as many people as possible to understand what mediation is and how they can be able to apply it. I wish to highlight that one of the unique additions that we have in our offering in this particular year is that we have a pool of mediators that is out to offer also vernacular based discussions on mediation. We are looking forward that we will be able to also host some of them in this channel, so that we can be able to ensure that mediation is understood in however best Wanjiko communicates, and also just to highlight. Just to kindly highlight what is in the pipeline for the Wasilianahub community. Next week on Thursday at 2 p.m., which is same time, we will be having a discussion with Mike Strano. Mike Strano is the founder of Fat Music and Entertainment, and he will be talking to us about disputes within the entertainment sector. And this is part of our discussions in this month, which is the creative economy, sports, and entertainment. Secondly, also is on 27th, which is on Thursday. On 27th, we will have a session with Mr. William Agan. Mr. William Agan is a professional mediator, and he's also an IP lawyer, which is an intellectual property lawyer. So we'll have session 1 at 2 p.m. on 27th with him. He will be taking us through intellectual property. This is now the area that relates to copyrights, the matters that relate to geographical indicators. And this is very useful, especially for business and enterprise. On 3rd of September, Mr. Agan will also have with us a session, which is a second session, still on the same topic of intellectual property. And we are looking forward that we can be able to have mediators and also other persons who have interest to understand the area that relates to intellectual property, because innovation and enterprise, today we will see a lot of need for such services. And the more mediators get an understanding, then the better you can handle these disputes, whether they come to you as privately or they come to you through the courts. The next session we'll also have will be on 17th of on 17th, that is on Thursday. Please book your diaries for that. And just to give you excitement, that on October 15th we have our Q3 symposium day. So we will be having sessions running from 7 a.m. to 6 p.m. Focused on mediation. And at 2 p.m. we will be hosting Mr. John Ohaga, who is in the Court Mediation Accredited Committee, and also who is a board of director for the Nairobi Center for International Arbitration. And he is a lawyer and very well versed in matters to do with dispute resolution. So, ladies and gentlemen, that is just to give you a highlight of what's coming up. But other areas, you will also be able to find them on the America Corner Moi Facebook page, as we also schedule the other sessions that are follow-up on mediation and dispute resolution. So, Emily, having concluded, we can say the national anthem. We close with the national anthem, and we will say it again. E Mungu nguvu yetu, ilete baraka kwetu, haki iwe ngao na mlinzi, na tukae na undugu, amani na uhuru, raha tupate na ustawi. I see a message from Susan Wendot that says, thank you very much for the discussion, Wangari and Emily, for moderating the session. God bless you all. So, ladies and gentlemen, please have the rest of the day. Emily, thank you for being a great partner. God bless.
Thank you. God bless you too.
Okay, we can say goodbye and as we close in the call.